Cell doors just slammed shut on a defense team, literally in a packed federal courtroom. Imagine this. U.S. Marshals hauling out lawyers in handcuffs. Right in front of the jury, their client, and a stunned gallery. These weren't criminals on trial. They were the defense attorneys fighting for their client. And in one explosive moment, Judge Sarah Caldwell turned the tables, detaining them for criminal contempt. This isn't courtroom drama from a Hollywood script. It's real, documented in an 18-page judicial order that's sending shockwaves through the legal world. Buckle up, because what happened here could change federal trials forever. Hit that subscribe button now if you want the full breakdown, because this story is exploding by the hour. What sparked this judicial fireball? A brazen, repeated defiance of court orders that escalated into outright sabotage. We're talking 17 documented violations over weeks, all laid out with razor-sharp detail in Judge Caldwell's contempt order. It started innocently enough, or so it seemed, with a pretrial ruling excluding prejudicial material to ensure a fair trial. But lead defense attorney Marcus Renard ignored it, slipping references into his opening statement 3 times. Judge Caldwell pulled him to the bench and warned him point blank, "Counsel, you're on notice. One more reference, and I'll hold you in contempt. Do you understand?" Renard nodded. "Understood, Your Honor." But the very next day, he did it again during cross-examination of the prosecution's star witness. Can you believe the audacity? Here's where it gets jaw-dropping. At the sidebar, Renard allegedly told the judge, "With respect, Your Honor, I believe your exclusion order was wrong, and I intend to appeal. Until then, I'll defend my client as I see fit." Witnesses say Judge Caldwell's expression froze like ice. She issued a formal warning on the record, instructing the jury to disregard. That should have been the end, but no. Over the next 11 days, Renard and his 2 associates ramped up the chaos, speaking over rulings, addressing the jury against orders, resubmitting denied motions to grind the court to a halt. On day 14, Renard talked for nearly 40 seconds straight after an objection was sustained, ignoring Judge Caldwell's repeated commands to stop. The transcript notes he overrode her 6 times that day alone. Talk about testing limits. Then came the breaking point, the moment that made history. During routine testimony, Renard introduced Exhibit 47D, excluded just hours earlier. The prosecutor objected furiously. But Renard? He held it up to the jury and declared, "Ladies and gentlemen, the court doesn't want you to see this, but I believe you deserve the truth." The gallery gasped. Judge Caldwell's gavel thundered down. Recess declared. Courtroom cleared. For 45 tense minutes, only the judge, clerks, and attorneys remained. When doors reopened, 4 U.S. Marshals flanked the defense table. Judge Caldwell delivered an 8-minute masterpiece from the bench. Every violation listed, every warning recapped, every chance to comply highlighted. Then the hammer. "Counsel, you've left me no choice. You're in criminal contempt. Marshals, remove the defense." Handcuffs clicked. The team was processed and held for over 6 hours before bail. If this grips you, smash that like button. It tells the algorithm to push real legal breakdowns like this to more people. But why did it escalate to this? Let's zoom out. The defendant, Raymond Voss, a former senior aide to a high-profile politician, faces wire fraud, obstruction of justice, and conspiracy charges laced with political venom from day one. Tensions brewed for months. Defense cries of prosecutorial overreach, media bias tilting toward the government. Enter Judge Caldwell, a George W. Bush appointee known for ironclad courtroom control. The defense tried to boot her with recusal motions, appeals, emergency stays, all denied. Analysts say that's when strategy shifted, from winning on merits to manufacturing appealable error. Force the judge into controversial moves, taint the trial, and flip any conviction on appeal. Sound familiar? It's a high-stakes gamble, but Judge Caldwell called their bluff early. In a pretrial transcript, she warned, "I won't be baited or provoked. This courtroom won't become a circus. Violate orders, face consequences." They violated within 72 hours, interrupting her, eye-rolling at rulings, breaching a gag order with media leaks. By week 2, 7 formal warnings. By week 3, 2 civil contempt fines totaling $45,000. Renard paid up and kept going. Civil slaps weren't enough. Enter criminal contempt and detention. Picture the scene at 10:47 a.m. Eastern. Packed courtroom, jury seated, witness testifying. Renard waves the forbidden exhibit. Prosecutor leaps up. Objection. Excluded 3 hours ago. Renard ignores. Tells the jury they deserve the truth. Gavel slams. Recess. Marshals enter. Renard's reported smile fades as Caldwell's statement dismantles his tactics. Handcuffs snap in silence. Witnesses call it unforgettable. Drop a comment. Have you seen courtroom chaos like this? I read every one. This isn't isolated history echoes here. Flashback to the 1969 Chicago 7 trial. Defense attorney William Kunstler racked up over 20 contempt citations for fiery arguments under Judge Julius Hoffman. But those were seen as overreach. Kunstler became a hero, Hoffman a villain. Real fact, Kunstler's convictions were later overturned. Contrast with 1988's Joseph Fine, jailed 18 months for shielding client info on principle. Or 2004's Lynn Stewart, sentenced to 10 years for smuggling messages from her terrorist client actions outside court. Renard's case, real-time defiance in open court, no noble stand, just calculated disruption. Legal historians say it's unprecedented in scale and enforcement. No wonder it's a defining moment. Experts are buzzing and unified. Jonathan Turley, GWU constitutional law prof, calls Caldwell's 18-page order strategically brilliant, an unassailable record against appeals. Real fact, Turley has testified before Congress on judicial matters. Ellie Honig, ex-federal prosecutor and CNN analyst, warns, this is real prison time, not fines. Handcuffing in court echoes nationwide. A former D.C. circuit clerk adds, Caldwell's methodical she preserved trial integrity. Even conservative Andrew McCarthy, National Review, says, a court order is law. No defending this. Harvard's Lawrence Tribe. This is judicial courage amid political fire. Consensus, Caldwell played by the book. If this deep dive hooks you, like it now, your engagement spreads the truth. So, what's next? For Renard and Associates, criminal contempt charges max 6 months per violation with 17. That's years theoretically, though likely less. Plus bar referrals, possible suspension or disbarment. Renard's 30-year career on the brink. For the trial, Mistrial declared. Voss gets new counsel, who'll argue irremediable prejudice for dismissal jury pool tainted by spectacle. But Caldwell's order notes Voss wasn't involved. Safeguarding retrial. Appeals courts? Unpredictable, but her documentation is armor. Long-term, federal defense attorneys rethink tactics. Some fear crackdowns on aggressive advocacy. Others say it targets only defiance. Real fact, the ABA, plans guidance, and ethics classes will dissect this for decades. Per NYU's Stephen Gillers. Every lawyer's rereading rules now. Renard made it worse post-bail. A fiery press conference attacking Caldwell as biased and vindictive, calling violations zealous advocacy. No remorse. Ex-Judge Nancy Gertner, Harvard. Worst move attacks hurt sentencing. Defense bar, silent, avoiding endorsement. Real fact, public attacks on judges can sway bars and appeals negatively. At its core, this is bigger than one case. It's the courtroom compact. Zealous advocacy meets fair rulings, all under rules. Renard tried to shatter it, create ungovernable chaos for appeal bait. If it worked, federal justice crumbles for plaintiffs, defendants, everyone. Caldwell defended the line, knowing backlash. That's not tyranny, that's rule of law. Real fact, similar tactics have tanked cases before, like in high-profile political trials where disruption backfired. Latest, attorneys out on bail, hearing next month before a new judge. Voss's dismissal motion pending, Caldwell likely denies. ABA statement, troubling, but no Caldwell slam. Bars investigating. Conservative media backs Renard as bias victim. Liberal outlets hail Caldwell's stand. Watch, sentencing jail time. Bar probes careers end. Dismissal ruling. Retrial. Appeals. Months. Years. That handcuff moment, it's reshaped federal practice. Marcus Renard bet no judge would act. He lost. Now every legal player knows the line. This isn't contempt, it's a reckoning. Subscribe and bell for updates. Sentencing, appeals, all incoming. Don't miss it.